Real estate condition report is the report that is required by the state of Wisconsin for all sellers to fill out. And this is a state statute, so this is irregardless of whether or not the seller is selling for sale by owner or listing with a firm. So if you are coming across a seller who, if you've got a buyer and you're writing on a for sale by owner, this might be a document that you have to provide to them because they might not have access. So a solo seller does need to fill out the real estate condition report as well. This report goes through and the seller, again, is the one who fills it out. The you as listing agents, for example, do not touch the real estate condition report. It's broken down and it does explain to the seller how to fill it out. But where I was going with this, I was just going to jump ahead and let you guys know that helping to fill out a real estate condition report would constitute as legal advice. So that's why it is a big no-no that we do not guide them on how to fill it out. So, but starting at the top, the address goes in this top section. And then the date that the seller is filling out the condition report is entered in this second section. Buyer's agents, when you are filling out an offer to purchase, you are going to use this date when referencing and incorporating the real estate condition report into the offer to purchase. And I believe that's on the second page of the offer to purchase. A buyer who does not receive a fully completed copy of this report within 10 days after the acceptance of the contract or sale or option contract for the above described realty has the right to rescind the contract. And that's also stated in our offer to purchases as well. So ideally, as a buyer's agent, you are receiving this real estate condition report prior to writing an offer. If not, though, it is stated in the offer to purchase that the seller has 10 days to get a copy of this over to the buyer. Notice to parties regarding advice or inspections, and it's spelled out right here. So real estate licensees may not provide advice or opinions concerning whether or not an item is a defect. Parties may wish to obtain professional advice or inspections of the property and to include appropriate provisions in a contract between them with respect to advice, inspections, defects, warranties. So yes, so if it's not, you're definitely going to come across a seller who's going to ask you about how to fill this out. And it's just nice because it's right there for you that you can point to this section and let them know that you cannot give advice on this. Section A now gets into the owner's information. So kind of defines and helps guide them on how to fill out the report. So in this form, aware means the owners have notice or knowledge. In this form, defect means a condition that would have a significant adverse effect on the value of the property, would significantly impair the health or safety of future occupants, or if not repaired, etc., would significantly shorten or adversely affect the normal life of the premises. So that's the definition of a defect. And that's also written into our offers to purchases. A3 in this form, owner means the person or persons that owns the above described real estate. An owner who transfers real estate containing 1 to 4 dwelling units, including a condo. By sale, exchange, or land contract is required to complete this report. And exceptions, Joan and I get tons of questions on this. 1 second, I'm gonna make sure everybody's muted. All right, cool, thanks. So exceptions to those who have to fill out a real estate condition report. So An owner who is a personal rep, trustee, conservator, or fiduciary appointed by or subject to supervision by a court and who has never occupied the property. So those two things have to coexist. So it has to be a court-appointed rep, trustee or fiduciary, and has never occupied the property. A lot of times the most common question that we would get would be like, children are the personal reps in this estate, but they lived on the property decades ago as children or as teenagers. They still have to fill out the real estate condition report. There is no like time limit on that. So just be aware of that, that they are not exempt. They do have to fill it out because they did live on the property at one time. And then an owner who transfers a property that has not been inhabited or who transfers a property in a manner that is exempt from the real estate transfer fee. So that has not been inhabited. So that is just really new construction. Another common question that Joni and I get are around investors. So my investor never lived on the property. Do they have to fill in a real estate condition report? Yes. The exception is only applied to if the property has never been inhabited, not because that owner never inhabited it. So at one time, these flippers, these flipped homes, excuse me, have been inhabited, excuse me. So yes, therefore the investor does need to fill out that real estate condition report. And it's arguable that a flipper knows more about the ins and outs of that property than anybody. You know, they're working on it day in and day out. So absolutely, they need to fill out a real estate condition report. And then another exemption are those who are any real estate that is exempt from the real estate transfer fee. So like churches, for example, the owners of a church building would not have to fill out a real estate condition report. All right. Owners represents that to the best of the owner's knowledge, the responses to the following questions have been accurately checked as yes or no or NA. If the owner responds to any questions with yes, the owner shall provide the additional information into the lines following that section. So it's very important as buyer's agents, if you receive, well, and as listing agents when you're reviewing, but as a buyer's agent, if you receive a real estate condition report that has any yes responses and there's nothing or no explanation in the lines below, we do need to inquire with that listing agent. And then on the flip side, listing agents, this is where you can help out in terms of how a real estate condition report is filled out. This would constitute an incomplete real estate condition report if they have not provided an explanation for any yes answers. A5, if the transfer is of a condo unit, the property to which this form applies is the condo unit, common elements of the condo, and any limited elements that may be used by the owner of the condo unit being transferred. A6, owner discloses the following information with knowledge that even though this is not a warranty, prospective buyers may rely on this information in deciding whether and on what terms to purchase this property. The owner hereby authorizes the owner's agents and the agents of any prospective buyer to provide a copy of this report and to disclose any information in the report to any persons in connection with with any actual or anticipated sale of the property. So all parties get a copy of this. Caution, lists of defects following each question below are examples only and are not the only defects that may be properly be disclosed. I'm not going to get into each. Oh, go ahead.
I'd like to interrupt that. That is critically important. A seller can think, well, it's not on the list here, so I don't have to disclose this, something about some kind of unit or some kind of defect within the house because it's not on the structure. They have to disclose that, and we've seen some lawsuits of non-disclosure because of that. And that was the seller's response. Well, it wasn't on the real estate condition report. So make sure that's clear. Section A is is very important. And if the seller doesn't read carefully or doesn't have the time to read, that type of person, it's not giving legal advice to read it to him, but you just can't make any interpretations. So somebody, if you read it to them, maybe slow it down, that'll help them understand. And that's not giving legal advice, but anything beyond that is. But it's really important. We had a lawsuit here a couple of years ago because the agent did not complete the entire, all of the check marks. I mean, the seller did not complete it. And that was the cause for incompetence.
Yeah.
Be careful.
Yes, thank you for that point. Yeah, I think it like the document itself does its best to guide sellers as best as possible, which is very nice. Okay, so then it's broken out into sections concerning the types of defects in like whether they're structural or mechanical, environmental defects, wells, septic systems, storage tanks, taxes, special assessments, and permits. So it's not just like physical defects that are described here. It's also just other material information. Notice of property tax increases. Are you aware of remodeling that was done that would increase the property's assessed value? So all of those types of questions have to be accurate as well. And you'll see at the base of each of these sections is where sellers have the opportunity to explain their yes responses. I have seen attachments to a real estate condition report in terms of, people running out of room, and just using a third page, sorry, I guess seventh page in this case. So that is an option for a seller as well. I was gonna make another point. It has escaped me, and that's okay. It'll come back. All right, then at the base, last page, it states here, or the questions are, owner has owned the property for blank years, owner has lived on the property for blank years. The owners will sign owner certification. And then buyer's acknowledgement. So your buyers will, once they receive this, they will sign it, and it will be a part of the offer to purchase. And then as a reminder, I'm going to go to MLS real quick. So if you are writing on listed property, let's see here. What's coming to mind? In the documents section, this is where you'll find the condition report and typically the lead-based paint addendum. I don't see that here, but you'll grab this, you'll make a PDF of this, and then you'll throw this into your zip forms to get the buyers to sign it as well.
And remember, the buyer's signature is not an acceptance of it or anything like that. As it says, it's the buyer's acknowledgement. All it means when the buyer signs this addendum, this record, that they acknowledge receiving it. And it needs to be signed when they do receive it. But it doesn't mean anything more than that.
Right. Doesn't preclude a buyer from attempting to negotiate on things that are named on the real estate condition report.
However, since they do see this in the record before they write the offer, they cannot use it as a defect if after the inspection. It may be brought up as a defect in the inspection, but because they were aware of it in acknowledging receipt of the RECR, they can't use it as a defect unless
Uh,
the contract is modified.
right. Which we won't get down that rabbit hole, I don't think. All right, any questions? Any questions so far from anybody?
Yes. If the inspection fall through and then there's something point out in the inspection report, then do they have to update this condition report to edit whatever that's shown in the inspection from the previous transaction that did not go to close?
If I'm hearing the question right, so if there's a real estate condition report provided and there's an inspection as a part of the offer to purchase, the seller would update the real estate condition report to reflect any new defects that they did not previously know about. But they would only do that if the offer to purchase, the current transaction fell apart. So yes, there is an amendment process, but that only happens if the property goes back out on the market.
There's actually an amendment to the real estate condition report.
Yeah. But based off of timing, you wouldn't do that at the point of negotiating repairs that come up on the inspection. So it does become new knowledge for the seller, of course. And that those are new defects that if a buyer decided to serve a notice of defects, if it got down to that, then they would name those things on the notice of defects because they're new defects that came up. But then and only then if the transaction falls apart, then the seller would amend the report to provide that updated information to prospective new buyers. Okay.
Yeah, and the reason you don't want to amend the real estate condition report while you have an accepted offer is because the minute you amend it with new items, that buyer now has a brand new rescission timeline.
Yeah.
So he could at this late part of the transaction rescind his offer.
Thank you for that.
As a list, if I'm a listing agent, I have to make sure all the spot on there, the seller have to complete it. Is that right?
Say that one more time. So your job as a listing agent is for the
To
seller
make sure the seller complete all the questions on
Yes.
the report.
Yes. So if you, and that was the case that Joni was referring to before, there was just like a handful of questions that the seller did not say yes, no, or NA to, and that constitutes an incomplete report. And that could have put the seller in trouble for not having that information. Like I can't remember. I mean, that was brought up between the attorneys, and that's what, so our job as listing agents, if you receive a real estate condition report before you're providing it out to the public, you're going to just do a scan and just make sure that everything is completed, yes, no, or NA. And then if you see anything that's not, then you can just point back and say, can you please answer this question? Okay.
Okay. So then there's also a part where after the transaction is closed, we have to submit it on command for compliance check. So during that compliance check, if we find out it wasn't completed, can they fix it after it was closed?
Well, you're doing your command submission like within 7 days after a offer is accepted. So this isn't happening after closing. So there would be an opportunity for our compliance broker to notice that and say, hey, wait a minute, have you double checked on this before closing?
Oh, okay.
So we got a lot of checkpoints in place. So
sorry, I do have another question.
Okay.
So when I was taking the exam for the real estate, they was mentioned that if I am as a listing agent and I notice any defect that the seller did not disclose, our job is to communicate that to both buyer and seller. And would that be in writing or would that just verbally?
Yeah, so and that is, yeah, we didn't get into that point, but thank you for that. I mean, so as your duty as a listing agent is to walk the property and inspect the property, at the time of listing it. And let's say you see a large crack in the foundation wall, and then you get the real estate condition report back, and the seller has not, reflected in his report that there's a big crack in the wall. You could go back to that seller and say, hey, I noticed this was not on the real estate condition report, and then having a conversation of, do you want to add this? And if not, I, as a licensee, have the duty to disclose this crack in the foundation wall if you're not. So there is a form for that, and that does come up. There's what's called the disclosure of material adverse facts form, that, yes, you would fill that out, just jot down what you notice, and all your responsibility is just to put what you notice, right? And then you are going to supply that to the buyers, or that goes to all parties. So yes, you would be making sure, like as a listing agent, you would put that in MLS, or making sure that it's available to all potential buyers, whether that's just direct email, whatever. But yes, that is the form you would use. So
Thank you.
Yeah, Leah has a question in chat. If there is something that needs to be disclosed that isn't on the record, how would they go about disclosing that?
Yeah, same
thing. They can they can attach an extra sheet of paper on the record and describe what the defect is and sign that. Seller signs that as well.
Yeah.
If there's no room.
Is that a form where they can just attach like a piece of paper, right, and spelling out something that they want the potential buyers to know?
Well, I think that this all comes down to timing. So if you catch something that's not disclosed on the record prior to receiving an accepted offer, you would just amend it.
No, I mean like something that's not listed. You said that earlier, that sometimes there's something on there they didn't disclose because they said it wasn't on the record for them to.
Right.
So do they just add an extra slip of paper and say?
Oh,
yes.
Yeah, I mean, I think there is like just a general, we can look at it. I think there is just like are you aware of any other defects?
Okay.
Like general.
And a good place to look for that is in the offer to purchase. I forget which lines they are, but it's a whole list of things that the seller is acknowledging are okay. Make sure that you go through that list in the offer to purchase too, and assure seller that everything is covered there. But if there's one of those that he is aware of, he does add that to that attached. It can be an attached blank piece of paper, or it can, as Steph said, there may be a kind of form for that.
Okay.
But if you just added separate piece of paper, you can label it, addendum X or whatever, and put that in as attached to the offer.
And there is just a general question, G5. Are you aware of other defects affecting the property?
Okay.
Yeah.
Yeah.
Okay. Thank you.
Yeah. Okay. Well, let's move on to, I think the addendum O was the other one. Go right at the top. So the addendum O is the occupancy agreement. And this, and Joan and I have seen way more prevalent in the last 5 years. Well, I wasn't reviewing offers prior to the last 5 years, so I feel like it's all I know. but I just know that they weren't used as much, you know, post or pre, you know, 5 years ago. But the addendum O is the occupancy agreement, and you would use this if there is a post-close occupancy period, meaning the seller is going to stay in their house longer or post closing. So if they're in their home for a time after the actual closing, or there's a pre-closing occupancy, which would mean that the buyer plans to occupy the home prior to closing. So 9 times out of 10, what we are seeing are post-closing occupancy by the seller. And I'll just start at the top. So this addendum is made a part of the offer to purchase dated. So like any of these addendums, we're referencing the offer by putting in the date, putting in the buyer's name and the address. You see this provision in all of the WRA addendums, inclusion of optional provisions. So terms of this offer that are preceded by an open box are part of the offer only if the box is marked with an X, and they're not part of the offer if it's marked NA or if it's left blank. I always like to take this opportunity to say that if you're not going to be using a provision or a contingency, still mark it NA. So that it's just crystal clear that it's not going to be included into the offer to purchase. And it also demonstrates if there's an issue post-closing that you have gone over that section with your buyers. So very good habit. Occupancy period. So starting line 9, the occupancy period is delineated as follows. Check the box at line 11 or at 14. So you're going to indicate whether it's a post-close or a pre-close. I'm going to put post-close occupancy in this example. Beginning at closing and ending on, and let's say it was, you know, a 3-week closing, or they just, or post-close occupancy, or they wanted to just go until the end of the month. So you'll mark it in there, and then you can even put in a time. So we're going to give them to the end of the day. We're going to mark it and be specific. Occupancy charge. So what we've been seeing lately is that buyers have not required an occupancy charge. Again, it's kind of another strategy that they can use in order to entice the seller to pick their offer. But if there were a daily charge, this is where you would put it. And a good rule of thumb is you can work out roughly what the mortgage payment is going to be for a buyer, and then add in the taxes and insurance. If you could have those. You would definitely have the tax number, not the insurance one necessarily, and then divide that by 30, and that gives a rough idea of how much that buyer would be paying per day. So that's kind of always a good rule of thumb in terms of what you're trying to find out to put here for a post-close occupancy charge. Held by, and usually this is given at closing. It's just credited right to the buyer on the closing statement. Payment is due at the beginning of the occupancy period, and so that's why it's usually found on the closing statement. Any unearned portion of the occupancy charge is or is not refundable based upon actual occupancy. So this is kind of a good one to make sure that you are catching. So it defaults to saying that any unearned portion of the occupancy charge is refundable based upon actual occupancy. So that means, you know, we've got a 3-week period in here. If let's say the seller decides they only need a week and a half, then they're committing here to refunding that money to the buyer. So if you want to make sure that that's not the case, you would need to strike is, so you can leave is not. Security deposit. Sometimes a buyer will want to charge a security deposit. I have seen this held by a third party. We at Keller would advise that a title company holds on to it, versus Keller Williams themselves. I've also seen that the seller, or sorry, the buyer slash owner would hold on to it. And then this could be used just, in any other security deposit case where, if there was damage done in the move out process, that buyer could deduct from the security deposit that they've charged to the seller. And then the seller, remember, becomes the occupant in this post-close occupancy period. Property taxes for the premises shall be prorated through the day prior to closing or the occupancy date. If neither is stricken, it's going to be occupancy date. Usually 9 times out of 10, I'm seeing it prorated through the day of closing. There's no wrong or right here. It's just, I'm just sharing norms. Condo or homeowner's fee. If the premises is a condo unit or subject to homeowners association, the occupant or the owner shall pay all the condo fees. So you can determine who's going to pay that here. Sometimes this is all worked in that post-close occupancy charge. So it kind of just depends on if you've made considerations for this number in that occupancy period charge or not. Utility charges. Occupant shall have all utilities services rendered in the occupant's name and shall pay all bills for utility services during the occupancy period. Almost always seeing that as being the case. We want to make sure that that seller slash occupant is maintaining and keeping their WE energies on and paying that bill. Maintenance. Occupant shall be responsible for all routine repairs and normal maintenance of the premises. Occupant shall maintain the premises, including any heating, sewer, plumbing, etc., exterior and grounds, and included personal property in reasonable repair. I want to get down to the meat of this. Any major repair or maintenance item shall be the responsibility of the owner. So that's the buyer. Major repair or maintenance item is anything costing more than, and you can name a number here. So usually I'm seeing $250 or $300 or $500 here. So basically it's saying, if the water heater goes out during this occupancy period, then the buyer, the owner, is going to take that on. Anything less than $500 and that might fail is going to be the responsibility of that occupant. So that seller. Keys. You're going to determine who and how many will have keys. So the occupant shall have, 2 keys. Owner shall have 1 key. And this is important. Line 55 or 54 to 55. Owner shall be admitted to the premises at reasonable times upon blank hours of advance notice. And this comes up a lot. So sometimes buyers will want to get into their new home and, I think the latest example I have from a couple weeks ago is an owner wanted to line up like 7 painters or something to get quotes, and told the seller that they had to be out for like a 7-hour period, and they did give proper notice. It's kind of an exception here because normally you're not necessarily having to ask the seller to leave, but point here is just like any kind of tenant landlord relationship, although I will state this is not a tenant and landlord relationship, but similar to that, you do need to give advance notice. That buyer needs to give advance notice if they want to get into the house. Removal deposit. So occupant shall escrow a removal deposit in the amount of payment of the removal deposit is due at the beginning of the occupancy period. I'm going to actually no here. In a post-closing occupancy, if seller gives possession of the premises to the buyer, on the occupancy date, the removal deposit shall be refunded to the seller. The removal deposit shall otherwise be released to the buyer per line 67 to 61 below in a pre-closing occupancy upon the closing of this transaction. I think this is actually a new provision, and I'm not completely sure where this would come in to play. Joan, do you have any ideas? Removal deposit shall otherwise be released to the seller.
It's just an extra security that the now owner has.
Okay.
That he's holding, it's sort of like an earnest money kind of thing. He's holding this removal deposit as security that this person won't leave this money behind it.
Got it. Okay.
But,
Gosh.
mm,
Yeah, that's interesting. We must have had an issue, obviously. That's how these things that's how our contracts get updated when there's an issue that we need to make sure gets covered. So
Well, that's the best thing about Addendum R. It has all these what ifs. And, you know, if
Yeah.
you're giving the original seller a few days to get tidied up after closing, you probably don't need a lot of these provisions. But if the seller has a long, say, a 3-month occupancy, you know, then you want to get into some real what if situations. And if you don't do this, we'll do this. And really know the person occupying the previous owner, you know, how do you know that they're going to fight getting out? They can
Yeah.
just say, no, they're not leaving. So you want to have these bound in a contract.
I actually do see what this is an adaptation of. So it used to be a daily deposit that would be named if a seller did not leave the premises. And now it's
just
one lump sum. So that is the difference. And I see now where they changed it. Okay. All right, failure to remove from the premises, optional legal action. So in a post-close occupancy, if the seller fails to give possession to the buyer on the occupancy date, the removal deposit stated on line 58, if any, shall be immediately released to the buyer. Okay. Yeah, before you would have to enforce that daily charge, and I'm sure it was just impossible trying to get money after the fact. Buyer may also initiate legal action to recover the possession of the premises from the seller, and seller shall be liable to the buyer for other charges imposed on the seller in this addendum. Okay, so that's what happened. Let's move to there. So I would be using this. I would definitely be check marking that and making sure that there's a removal deposit. Use of premises, occupant shall be entitled to peacefully and quietly have, hold, and enjoy the premises during the occupancy period. I think this goes back to that disruption with 7 contractors coming in on one day. Occupant shall make no changes, alterations, or improvements to the premises without the prior written consent of the owner. The occupant is prohibited from assigning or subletting their occupancy rights. Hold harmless. The occupant shall hold the owner harmless for all liabilities, claims, or expenses resulting from occupant's use. Parties agree to hold any person or entity harmless for good faith disbursement. And then this is new to the this form as well. It's not a landlord-tenant relationship. So therefore, it's not subject to tenants' rights. So you cannot look to those if there is an issue between how the tenant seller is treated or mistreated or what have you. Or anything subject to landlord tenancy would not be applicable to this.
Yeah, a good example of that, I had a situation, I think last year, where the owner, the occupant, was saying, I don't have to leave now, you have to give me 30 days notice. Even though the date was in the contract that they would leave, all of a sudden the occupant is throwing around all these tenants' rights and I need 30 days notice and something like that. No, they don't have the 30 days notice provision or anything like that. This is according just to the dates that are in this agreement, whether it's in the addendum R or actually in the contract. So.
Yeah. That's an excellent example of that. Insurance may not be available for the occupancy period. Parties should consult with their insurance agents regarding availability and cost. Insurance requirements, if any, for this occupancy period shall be. And sometimes I have seen owners want the sellers to take out an additional like renter's insurance policy. But that seller / occupant should just consult with their insurance provider, or the buyer / owner should consult to find out what might be available to them as well. But just know that what's required is the actual homeowner's insurance policy will need to be in place by the time there's a closing. So that is already going to be effective and being taken care of by the owner. So this just kind of applies to any additional coverage. All right, and then just like any of our addendums, so this is an acknowledgement. Buyers and sellers are all acknowledging on 104, 106. And just like any term in our offers, this is negotiable. So let's say, what I see often is if any term is going to get negotiated or renegotiated, I would say it's maybe an occupancy charge, maybe the security deposit. So just because buyers and sellers are signing this is not an acceptance, this is an acknowledgement.
And remember to either have it attached to the offer if you're writing this with the offer, or do an amendment stating that this is addendum R is now part of the offer to purchase.
All right, I'm gonna go back. I got about 9 minutes. I think the last one, so that was the addendum. Oh, and we could do the addendum R real quick. Any questions while I'm trying to pull this up? Okay. All right, the addendum R to the offer to purchase is used for rental properties. So and it's not set in stone that this has to be used, but again, there are just like in the addendum O, there are additional protections for all parties that we definitely advise everyone to use this. So the top line should all look familiar. The property is subject to rental agreements, either written or oral, for a definite period of time. Buyer takes the property subject to tenants' rights. The rent schedule can be named in lines 10 through 19. There's provisions on leases, so complete copies of all current written leases and all rental applications received for the current tenants are attached to this offer, or shall be furnished to the buyer within blank days of acceptance. So it might be the case where you would receive a copy of the leases prior to receiving an offer. Listing agents, I'll say, if you are listing property that has tenants currently in the home, get those right away from sellers. That's just going to be in your checklist of things to get. And I would put them right into MLS as well and get those available right off the bat. But if they're not available, we can indicate in here that we want to make sure they're furnished to the buyer within so many days after acceptance. So I think a reasonable time would be like maybe 3 days. If the buyer does not receive these documents by the applicable deadline, or if the lease terms or rental applications are materially different from the seller's representations or do not comply with applicable law, buyer may deliver written notice stating seller's non-compliance to the seller within blank days of acceptance, and the offer shall be null and void. That's really nice that it's just like all spelled out. The roadmap for a buyer being able to declare the offer null and void because they did not receive these leases is great. There's no gray area here. So you got to get those over to the buyer, or if they want, they can declare the offer null and void. Personal property, the following appliances and equipment are not fixtures. They are included in the sale and are now and will be at closing in good working order. So I would just go in and, you know, if you're writing on a 4-family, if there's 4 refrigerators, just go right in and name them all. There's 4 dryers, maybe not, maybe there's only 2 dryers. Total value of these items. You know, if you don't have it's not necessarily to indicate a value right there. I have not usually seen that actually. Indemnification. So at closing, the seller shall assign all right, title, and interest to the leases to the buyer, and buyer shall assume all duties, liabilities, and obligations that are under. Buyer shall indemnify and hold the seller harmless from any claim or loss first arising from events occurring after closing. So, you know, once it closes, buyer is now the landlord. And, you know, any losses after that are no longer the seller's responsibility. Rent, all rent for the month of closing shall be prorated through the day prior to closing. Seller may collect any delinquent rent which was due before closing for seller's account. Seller cannot use security deposits for delinquent rent. Maintain rental operations unless otherwise agreed by the parties in writing. Seller shall give delinquent tenants appropriate notices of default. These are a lot of just good covers, CYA for buyer to make sure that, you know, these things are going to be done if there are issues. Vacant units, except as provided on line 67 to 70, seller shall or shall not rent vacant units. So as a buyer coming in, if you see the home and it's one of the units is currently vacant, you would want to make sure that it remains vacant if that's a unit that you intend to occupy, for example. Change in tenant status, seller shall give buyer prompt written notice of any tenancy and termination, unit abandonment, tenant plans to vacate, or a material breach of a lease that is occurring or continuing for more than blank days. And this comes up. So if, you know, maybe at the time of the offer, all tenants were in good standing in terms of rent, but let's say it's, you know, 7 days have gone by and we have not received rent. The seller has not received rent from one of the units. The seller needs to notify the buyer of that, even though the buyer does not know it or does not own this property yet. Rental agreement extensions and renewals, seller shall not, without buyer's written consent, renew an expiring lease or extend a lease term, change the terms and conditions of a lease, a month-to-month tenancy or other periodic tenancy, or enter into a written lease with a month-to-month or periodic tenant. Security deposits, seller shall transfer all security deposits to the buyer at closing. Seller may pursue any claims that the seller may have against tenants directly against the tenants. Tenant records, seller shall give buyer a copy of all tenant records. Just a lot of good stuff for, mostly for the buyer here. Notice of contact person changes. So the seller and the buyer shall give all tenants written notice within 10 business days of closing, advising them of the sale. And this is nice. The buyer is saying right in here, well, defaults to the buyer, but the buyer is committing right in here to state that they will make sure that they're notifying the tenants of the new ownership. Eviction of after closing, seller shall complete any eviction action begun before closing at seller's cost. Unless buyer's cost, move the court to substituted or joined as plaintiff. Seller gave tenants notice prior to closing to vacate the premises and the tenants have failed. To timely comply with the notice by the time of closing, the seller or the buyer shall take the steps necessary to remove the tenants. It defaults to seller. So as a buyer's agent, I would want that to be on the seller to take action if eviction steps need to be started. Delinquent rent collected, any delinquent rent or fees collected after closing pertaining to rent due and payable prior to closing shall be paid to the seller's account, unless agreed by other parties in writing. That's nice for the seller. So if the seller is able to collect delinquent rent after closing, it will go back to the seller. Following provisions are part of this addendum only if marked with an X. Requested vacancies, seller shall give all notice necessary to terminate the tenancy. So if the buyer wishes, they could ask the seller to give notice to their tenants. If one or more units which were occupied on the date online, one of this offer are vacant on the day before closing, buyer may deliver to seller a written notice of termination, and this offer shall be null and void. Oh, that's interesting. That's an aggressive move. Okay. I haven't seen that yet. Default number of days is 20 if nothing is entered on blank lines requiring entry of a number of days. Okay. Yes. So like with all of these, come to Joni or I with assistance. But what we want you to hear is that, in these, just kind of, well, I mean, they're common. In these instances where there's a post-close occupancy, or if if you're writing an offer on a home that has, on a 2-family or a 4-family, to use these addendums, because there's just a lot of language in here that is not reflected in the offer to purchase. So that will help all parties immensely. So any questions?
Steph, you did a good job. Thank you.